Limited.
Thank you. My name is Bob Barnes. I cover the court for the Washington Post, and we're going to be talking about the civil rights docket, a couple of cases that are there already, some things that might be headed toward the court. I think that you've already heard from two of our panelists. We have two, they're being joined by two others, Pam Karlan from Stanford University and Paul Smith from the Campaign Legal Center and Georgetown University. These guys are true experts, and they have a wide range of experience and outlook, which ranges from the left to the far left to the fringe left. And I'll let you figure out who is who on that. So to provide some balance, once in a while, I'm going to attempt to do my impersonation of the wince and grimace of Justice Alito when he hears something that he disagrees with. It goes like this, kind of. And he's okay.
Just trying to get to a seat.
And if you've never been to an argument and to watch Justice Alito, I think it would be fair to say that he's the justice you would most want to invite to your poker game, because it's very clear what he's thinking about what he is hearing. The first case we're going to talk about is sort of a companion to the case that was the moot last night. That one was about Title VII and sexual orientation. This is a Title VII claim that was brought by a transgender woman against the funeral home where she has worked for a long time and then was fired. So I'm going to ask Erwin if he will give us the details of that case, and then we're going to ask Pam and David, both involved in the issue, to talk about how it raises issues that might be different from the case on sexual orientation.
Thank you. The case is RG and GR Funeral Homes versus the Equal Employment Opportunity Commission. It will be argued on Tuesday, October 8th, the same day that Pam's going to be arguing the Altitude Express versus Zarda and Bostic versus Clayton County case, which was the base of the moot court last night. As was pointed out, Anthony Stevens worked for a long time for the funeral homes. The funeral homes have dress code requirements that do play a role in the briefing in the case, men being required to wear suits when they're funeral home directors, women required to wear suits with skirts. Anthony told the funeral home in a letter that he was going to be transitioning and described the process of transitioning, and he was going to become Amy. And the owner of the funeral home, after thinking about it for 2 weeks, said, basically, you're fired. He said that he's a devout Christian, and under his Christian beliefs, gender is something that's determined genetically and at birth, and it would violate his religious beliefs so as to have a transgender individual working for his funeral homes. Amy files a complaint, a charge with the Equal Employment Opportunity Commission. The EOC finds that this is a form of sex discrimination in violation of Title VII. Attempt to settle the case fails. A lawsuit is filed in federal district court. The district court denies the motion to dismiss, but then ultimately grants summary judgment in favor of the funeral home, but based on the Religious Freedom Restoration Act, based on the religious beliefs of the funeral home director. The United States Court of Appeals for the Sixth Circuit, an opinion by Judge Karen Moore, reverses and finds that this is discrimination on the basis of sex, that it's discrimination on the basis of sex stereotypes, and rejects the religion claims. The Supreme Court grants cert on two questions, both related to Title VII. Does it violate the Title VII prohibition of discrimination because of sex to discriminate against a transgender individual? And second, is this discrimination on the basis of sex stereotypes in violation of Price Waterhouse? The case has now been briefed before the Supreme Court, and there's some interesting things about the briefs. The United States government, the Solicitor General's office, came in on the side of the funeral homes not on the side of the position of the Equal Employment Opportunity Commission. And if you look at the cover of the SG's position, they are the respondents in the case, but it says on the cover, respondents urging reversal of the Court of Appeals. You don't see it that frequently in the Supreme Court. There's also a large number of amicus briefs. I tried to count, and I found, and my count may not be precise, 47 amicus briefs in favor of Amy Stevens, 42 amicus briefs inside of the funeral homes and the position taken by the United States government. So it's about 90 amicus briefs in the case. And one of the interesting things from an advocacy perspective is it a good thing to have 90 amicus briefs in a case? Is it better if there's some way, and is there some way of limiting them? One other thing that's interesting about the briefs in the case is the pronoun. The individual who brought the claim clearly says in her brief that she wishes to be identified as she and with female pronouns. And yet you find in the brief from the funeral home and many of the other briefs, they refuse to do that. Either they refuse to use the female pronoun or they simply referred to by last name. And so you see in the use of pronouns, the fight over the whole idea of how are they going to respect somebody being a transgender individual or not respect somebody being a transgender individual. As I said, there's two issues in the case. The first is the discrimination against a transgender individual discrimination because of sex in violation of Title VII? The funeral homes in the United States say no to that. They say that Title VII requires that a man and a woman be treated the same. The funeral home in the United States say that in this instance, the funeral home would treat a man who had transitioned the same as a woman who had transitioned. Therefore, it's not discrimination because of sex. That this was a man who had transitioned to a woman, but if it had been a woman who had transitioned to a man, they treated exactly the same way, and therefore it can't be seen as discrimination because of sex. Also, both the funeral home in the United States say that when Title VII was written in 1964, because of sex, did not have in mind protecting transgender individuals. The second argument that's raised in, or I should say, here, the person who initiated the lawsuit, Amy, argues in response to this is very much discrimination because of sex. That as a transgender woman wearing a skirt, she was being fired, but if she were not a transgender woman and she wore a skirt, she wouldn't be fired. Or if a man wore a skirt, he would be fired, was presenting himself as a female would be fired, but a man who presents himself as a man isn't. And in this sense, there is a similarity to the argument that you heard last night of what does it mean to discriminate because of sex. The second issue that's presented in the case involves whether this is discrimination on the basis of sex stereotype, which Price Waterhouse said is impermissible. And here what the funeral home in the United States both says, this isn't discrimination because of sex stereotype. They say this is determining what it means to be male or female. And they say this is something that's determined by birth. And it's not about stereotypes at all, which makes it very different than Price Waterhouse. And of course, what's argued on the other side is this is all about sex stereotypes. It's all about how one is presenting oneself from a gendered perspective, and that therefore cases like Price Waterhouse and Nkali are very much on point. It's also worth noting that the funeral home's brief makes a lot of arguments from a policy perspective. It says at the end of its brief, if the Supreme Court were to recognize that Title VII applies to protect transgender individuals, then that would lead to unisex bathrooms. It would lead to real problems with regard to Title IX, which requires equality of funding for sport, and prevents educational institutions from discriminating on the basis of sex, including requiring equality for sports. It says it would create problems with things like rape shelters and the like, and battered women's shelters, and says that for all of these reasons, the court shouldn't expand Title VII in this way. And the exact phrase that's used in the brief is rewrite Title VII in this way. Whereas the argument on the other side says none of those issues are before the court here, none of these have been briefed, and all of them can be dealt with in due course when the time comes. So that's the basic presentation.
Thank you. There's an, I think, interesting thing in the briefing that this letter was sent to the funeral home director and the fellow employees saying, when I returned to work after vacation, I will be Amy Stevens, dressed as a woman, the way I feel I am. Was fired because the funeral director said quite plainly, this is a man who wants to wear a dress, and we can't allow that. The brief also says that Amy Stevens was advised that she had to live as a woman for a year before beginning a transition. And so it raises a lot of fascinating questions, it seems like. David, your organization is representing Amy Stevens. What would you like to add to this?
I think that for those of you who were here last night, there's obviously tremendous overlap between the question of whether discrimination on the basis of sexual orientation is discrimination because of sex, and discrimination on the basis of transgender status is because of sex. I think, the way I think about it is, are transgender status and sexual orientation categorically different from sex discrimination, or are they subsets of sex discrimination? If they are subsets of sex discrimination, then they should be actionable under Title VII. And I think there are very strong arguments that they are subsets of sex discrimination. To me, the easiest argument is the stereotype argument, and it's in some sense easier to make in the transgender case than it is in the sexual orientation case, simply because the Harris Funeral Home's operator was very explicit about the stereotypes that he put forward to justify firing Amy Stevens. There are many versions of it, but my favorite one is a male should look like a man and a female should look like a woman. That's a stereotype, right? That is, some females look like women and some males look like men, but we know that there are many who don't. And in fact, in this country, there are 1.5 million transgender individuals. So if Harris Funeral Homes had fired a female employee for not looking sufficiently female, that employee would clearly have a sex discrimination claim under Price Waterhouse. That's essentially what Price Waterhouse did. It did not promote Ann Hopkins to be partner because she did not walk femininely enough, talk femininely enough. She was too aggressive. She didn't fit the female stereotype. Well, in this case, the only difference is that the individual who's suing is transgender rather than non-transgender, but they're still being fired for failing to conform to a stereotype. Males should look like men, females should look like women. And both Harris Funeral Homes and the United States government concede that Title VII does not exclude transgender people, that they are just as protected from sex discrimination as are anybody else. And so the narrowest way to decide it would simply be that. These are, he justified it on the basis of sex stereotypes, and there's no reason that transgender individuals are excluded from that general protection. I think to me, the argument on the other side is the argument that, no, we're not discriminating against people because of their sex. We're discriminating against men and women equally if they are transgender. Right, that's the notion. And transgender is something different from sex. But if transgender is actually just a subset of sex discrimination, then that's not really an adequate response. And I think one way of seeing that this is not, this sort of equal treatment, it does not negate the act of discrimination, but actually doubles the act of discrimination, is to imagine the Price Waterhouse case, where Price Waterhouse didn't promote Ann Hopkins because she was seen as not sufficiently feminine. As the United States concedes in this case, if Price Waterhouse had also refused to promote a male employee because he was insufficiently masculine, that would not negate the discrimination. It would double the discrimination. It would be guilty of 2 acts of discrimination. So in this instance, Amy Stevens was fired because she fails to look sufficiently male when she lives and presents herself as a woman. He is enforcing against her an obligation that because she was assigned male sex at birth, she must appear male. And if he turned around and said, well, someone who is assigned female sex at birth must also live consistently with their sex, that is enforcing against that individual a female stereotype, right? That she must live and appear as a female. The enforcement against men of a male stereotype is not negated by the enforcement against women of a female stereotype, and vice versa. And so I think, I think I will stop there. Happy to talk about dress codes if people want.
Pam, can you talk about how you see these cases either fitting together or being separate? Well, they are separate, but different, let's say.
Sure. So let me just say something, 3 points about the Stevens case that I think are interesting insights into the court. One builds off of what Erwin said about both the Solicitor General and the company going out of their way not to use any pronouns in their briefs. And a couple of years ago, the Supreme Court had a Title IX case involving a transgender individual, the Gavin Grimm case. Gavin Grimm is a transgender boy. And one of the amicus briefs that was filed in that case, because he was a child at the time, the way the case was captioned was GG and his next best friend, which is the way of referring to the parent. And the brief said on its cover, GG and her next best friend, and the clerk's office of the Supreme Court actually sent the brief back to the party and said, you've got to use the proper caption in the case. So it'll be interesting to see at oral argument how the Supreme Court refers to Ms. Stevens and the like. Second interesting point I think about the case is the Supreme Court rewrote the question presented here. That is, the funeral home wanted to focus on dress codes a lot. And the Supreme Court rewrote the question presented so dress codes don't appear anywhere in the question presented. And yes, yet both the company's brief and the government's brief spend a huge amount of time on dress codes and bathrooms. And this case is not really about either because, the funeral home would have fired her regardless. The third point, which I find deeply ironic in this case, is this is a funeral home that has not in the last 25 years hired a woman to be a funeral director. So it's kind of, there's something just atmospherically odd about this, which is they wouldn't have hired her if she had transitioned before she got there and came to them and said, my name is Amy Stevens, I want to work for you. They probably would have refused to hire her without knowing her gender identity at all, on the grounds they're not hiring women, and they would have been liable. So, so there's all this kind of weird undertone to the case. I think the cases, are tandem cases. There are some differences between them that I find really interesting, and one of the ones that I find particularly interesting is the role that religion plays in the two cases in two separate ways. One is that Harris Funeral Homes really is refusing to continue to employ Ms. Stevens because of the religious views of the employer. And you don't have anybody in the Title VII sexual orientation cases directly raising the religious objection, although there's this undertone there. The other thing, though, is an argument that's in the brief from Ms. Stevens, which is an analogy to religion, which is it would be religious discrimination if an employer said, look, I'm fine with hiring Christians, I'm fine with hiring Jews, but anybody who changes their religion, I'm going to fire them, because I think you've got to stick with the religion you were born into. As changing your religion is, no, I mean, discriminating against somebody for changing their religion is religious discrimination, and there's nobody who says it isn't. And so one of the arguments that's made in Ms. Stevens' brief is, well, think about the analog here, which is what they're really firing Ms. Stevens for doing is changing from the gender she was assigned, the sex she was assigned at birth on her birth certificate, to what she perceives her sex to be. And if that would be religious discrimination, then this is discrimination on the basis of sex. And that's an argument that I think is distinctive to the Stevens case, as opposed to the Zarda and Bostock cases, where people are not saying, well, I changed my sexual orientation and that's why you're firing me.
Paul, you want to comment? And then Paul's going to lead us into our next case.
One of the interesting questions about these tandem cases is whether there's a way to come out differently in the two situations, the transgender case versus sexual orientation case. And there is an instinct some people have that the transgender case is easier because it seems like it's more about because of sex. When a guy goes home, comes in as a woman on Monday morning and is fired for that reason, it seems like that's about, precisely because of this kind of religious conversion argument, which is actually a very powerful metaphor, I think. The Trump administration told the court to take the sexual orientation cases and not to take the Stevens case, because I think they probably see that as a more likely win for the plaintiffs, or at least they did at the time. And so, one of the interesting questions will be whether the court finds a way to rearrange itself and come out differently on the two. I'm not necessarily predicting that, but I certainly think it's possible.
Not surprising that the man gets the easy case, the woman gets the hard case.
Just happy to be in the show.
I think there are ways in which, for the reason Paul suggested, that the transgender case is easier, but there's also a way in which it's much harder, which is that the court has been dealing with gay people and cases involving gay and lesbian people for quite a while now, and they've been educated about sexual orientation in a way that I think they haven't been really educated about transgender individuals. And I think that'll probably come out at the argument in terms of the way people are referred to and the like. It's just, it's almost like we're back, in the early days of the sexual orientation cases where the justices said, well, I never met a gay person, right? Mm-hmm. So I do think that in that cultural way they're different. I think the fact that they're coming together at the same time will be hard for the court to decide them separately.
All right, Paul's going to tell us about another case that the court has already accepted.
So the last cases were about whether something is because of sex. There's a case that's about whether discrimination was because of race, although they don't actually use that terminology in the statute. The Comcast case that is being heard this fall by the court involves a very important Reconstruction era race discrimination statute, 42 U.S.C. section 1981, which says that all persons have the same right to make and enforce contracts as members of the white race. This is the phraseology used in 1866 when they passed the law. But basically, it's a law that says it bans racial discrimination in the making and enforcing of contracts, which includes employment contracts, but also lots of other kinds of contracts. And the question in the case is, what does it mean, what kind of causation do you have to get past the pleading stage and prove your case if you're claiming that you were denied the opportunity to enter into a contract because of your race? And the dispute is over whether the plaintiff has to show that race was the but-for cause for the denial of the opportunity to enter into the contract, or it's enough just to show that race was one of the factors, or at least a finder of fact could determine that race was one of multiple factors in a mixed motive kind of situation. The case involves an African-American owned network of cable stations called Entertainment Studios Network that has spent a lot of its energy for the last decade or more trying to get carried by the various cable and satellite systems we all use to get TV at home, Comcast, Dish Network, and all that sort of thing. It's had some success with some of them. It did not meet with success with Comcast, which said we're not going to find a room in our 500 channels for your stations. And eventually the owners of the company and a trade association they had set up sued claiming that they were denied the opportunity to enter into a contract with Comcast because it was a black-owned company. And then the question is, what do they have to be able to show to get past the pleading stage of the case? The district court dismissed the case, saying you simply don't have enough plausible evidence to show that race was the actual but-for cause for Comcast doing this rather than some legitimate business reason. And the Ninth Circuit then reverses, saying that's too high a standard. There was some reason to think in the allocations that race had at least some role to play here in the decision that Comcast made. They had, while this whole conversation was going on, they had let some even less well-known white-owned stations onto their system, and maybe the jury could infer something about that. So go back and let the case go forward based on the at least partial motive analysis. And so the issue is, how much do you have to have? The plaintiffs are going to argue that the Supreme Court already resolved this issue back in the 1980s in a case called Patterson versus McLean Credit Union. On the other hand, Comcast says that's not so, and the Justice Department is on Comcast's side against the civil rights plaintiffs again in this context. And really what's at stake in the case is a lot of the times when you're coming in and you're claiming race discrimination as a plaintiff, you don't have discovery yet. You have certain kinds of what look like disparate treatment, but you want to be able to get past the complaint getting dismissed and getting into discovery and really be able to prove the case. And you also, a lot of, under Title VII, what they do very often, the other big employment discrimination statute, if you come in with a plausible claim of racial motivation, the burden then shifts to the employer to defend the decision that was made. And I think ultimately that is the question. Should we have that kind of burden shifting structure versus simply requiring that the plaintiff have from the beginning of the case clear but-for proof of racial motivation in the particular action that they are attacking. And having given that summary, I will recognize that this is actually Erwin's case, so he can now correct everything that I have just said wrong.
No, everything you said was right.
How did he screw it up?
No, as always, it was perfect. Just a
Thank you,
word about
Professor.
no, it's good. Just a word about the procedural posture of the case, and then maybe elaborate at least what's at stake in the case in terms of the arguments. The plaintiff is really a man named Byron Allen, who owns the Weather Channel, and he also owns a number of cable channels. And many carriers, DirecTV, Dish TV, carry it, but both Comcast and Charter Communication didn't carry his channels. So he filed two separate lawsuits in federal district court in Los Angeles, one against Comcast and one against Charter Communication. The district court dismissed the Comcast case for failure to state a claim, but in a very short opinion without much elaboration. The district court denied the motion to dismiss in the Charter Communication case, but certified a First Amendment question to the Ninth Circuit. Would it violate the First Amendment of Charter Communication to force them to have to carry the channels that they don't want to carry? Both cases were argued the same day in the Ninth Circuit. The Ninth Circuit wrote its opinion in the Charter Communication case, and in Comcast basically said, we've decided the issue with regard to Section 1981, see what we said in Charter Communication. Both filed cert petitions. Paul Clement filed the cert petition for Charter Communication. Miguel Estrada argued the case on the other side in the Ninth Circuit for Comcast, filed the cert petition there. The court took the Comcast case and is holding the Charter Communication case on the docket. And I think there's several different issues that are before the court. One is about precedent. My argument is that in Patterson versus McLean in 1989, the Supreme Court expressly adopted the motivating factor, burden-shifting approach, and said it's the familiar one that's often used in Title VII. On the other hand, what Comcast says is Congress amends the Civil Rights Act of 1991. It could have put motivating factor in, but didn't do so. Now, of course, the response to that is Congress adopts the Civil Rights Act of 1991 to overrule some 1989 decisions that were restrictive with regard to civil rights. It didn't feel a need to change something that was advancing civil rights. There's also arguments in terms of the statutory language. The brief for Comcast says repeatedly, the plain language of the statute is clear that's to be but for causation. The argument on the other side that I make is statutes that use words like because of or based on have been interpreted as having a requirement for but-for causation. Section 1981 doesn't use the language. 1981 says you have to treat people the same as white people. And so I actually found 1865 dictionaries that define the word same to support the argument you're not treating blacks the same as whites if you're using race as a motivating factor in the decision not to contract with them. A third argument is what was tort law in 1866? Now, we can make an argument, given the language of the statute, should we even be looking at the tort law of 1866? But there's the sense that the court well might do that. With regard to Section 1983, that was adopted in 1871, the court says it was written against the backdrop of common law. Comcast cites authority that says that but-for causation was the norm in 1866. My argument is, but those were all negligence cases, and actually for intentional torts cases in 1866, there wasn't a notion of but-for causation, and authority like William Prosser and G. Edward White who said that. And finally, there's the question, if it matters, of what was the statutory purpose in 1866? Now, some justices may say the statutory purpose doesn't matter, it's just about plain language. On the other hand, some justices do look to statutory purpose. I think it's clear from what the Supreme Court has said that the Civil Rights Act of 1866 had a broad remedial purpose. And ultimately, then the question would be, think about these two different ways of interpreting the statute. There's the one that Comcast and the Chamber of Commerce want that's going to be much more restrictive in terms of the ability of plaintiffs to bring suits. Much harder if the standard of pleading is but-for causation. And then there's the approach that the civil rights organizations that are filing amicus briefs want, and that here the plaintiff wants, that's going to make it much easier for plaintiffs to bring it. And if you think about what Congress was trying to achieve in 1866, the year after the Civil War, isn't it clear which of those purposes is more in accord with Congress's goals? So those are what I see the arguments as being about.
All right. I'm going to go through a couple of other things and then leave time so that you can ask questions. I'm sure that you will have some. You might remember a few years ago a case called Masterpiece Cake Shop, in which Colorado baker Jack Phillips declined to create a wedding cake for a same-sex couple. They couldn't get married in Colorado at the time. They were going to Massachusetts to get married, come back, have a reception. They went to his shop to talk about a cake, and he says that their conversation lasted about 20 seconds, where he said, "Sorry, guys, I don't make cakes for same-sex couples." And he said he would sell them other items in the store, but they never got around to the conversation about what this cake exactly would be. The Colorado Civil Rights Commission said that his actions had violated Colorado public accommodation laws, which protected on the basis of sexual orientation. And the case eventually made it up to the Supreme Court, where we all expected something big to happen, but it didn't. Justice Kennedy wrote a majority opinion in which it's very hard to count the number of buts on the other hands and neverthelesses in his opinion. He basically came down on the fact that some comments made by some members of the commission showed that they were prejudiced against Jack Phillips's religious beliefs, and the court sent the case back on that basis. And Justice Kennedy was pretty frank about acknowledging that they had not settled the question. What he wrote was that future cases that raise issues about religious and free expression, free speech beliefs versus the rights of same-sex couples to equal treatment. He said that future cases, quote, must be resolved with tolerance, without undue disrespect to sincere religious beliefs, and without subjecting gay persons to indignities when they seek goods and services in an open market. He didn't add, "I'm out of here, good luck," but you can kind of hear that might have been the next sentence. So at the same time, the court had another case that it didn't get to. that involved a florist in the state of Washington, operates a shop called Arlene's Flowers. She has the wonderful name of Baronelle Stutzman, and she had a longtime friend who was gay. She said that she had created arrangements for anniversaries and for birthday parties for him, but when he came and asked her to do the flowers for his wedding, she said, "Sorry, I can't do that. I can't do a same-sex wedding. It offends my religious beliefs." She says she gave him the names of some other florists, but the story got out. The Attorney General of Washington filed a suit against her. And then eventually he and his partner did as well. The courts in Washington said that she had violated the state of Washington's law. So the case was waiting. The court, instead of taking that case after Masterpiece, sent it back and said, do this again with what we told you in Masterpiece. The Washington Supreme Court did. They then ruled again unanimously the way that they had before and said that there was no religious animosity on the part of any of the adjudicators in this case, and so the judgment stood. It's now back at the Supreme Court, and the complaint is that the Attorney General, and one part of the complaint is that the Attorney General was sort of selective in prosecution. There was another case in which a coffee shop owner ordered some people out of his establishment because he disagreed with their religious views and statements that they had made, and that the Attorney General didn't go after him. So that case is waiting. And then in the meantime, there was a case from the Eighth Circuit with a group called Telescope Media. And Judge Strauss, I would say, has written this nut graph that Supreme Court reporters would love to have in cases. He writes, Carl and Angel Larson wish to make wedding videos. Can Minnesota require them to produce videos of same-sex weddings, even if the message would conflict with their own beliefs? The district court concluded that it could and dismissed the Larsons' constitutional challenge to Minnesota's anti-discrimination law. Because the First Amendment allows the Larsons to choose when to speak and what to say, we reverse the dismissal of two of their claims and remand the case to the lower court. There was a dissenting opinion by Judge Kelly that said the Larsons concede that they want to operate a public accommodation that serves only opposite-sex couples. Minnesota's law prohibits that conduct, just as it would prohibit any hotel from denying its services to an individual based on race, any store from refusing to sell goods to a person based on religion, or any restaurant from charging higher prices to women than to men. So nice, clear statements in that case, which I think sets up the question and this tough issue that Justice Kennedy left the Supreme Court with. And so I'm hoping the panelists will weigh in on that. And also this sort of spot that the justices seemed to find themselves in when they were hearing arguments in Masterpiece, which is what constitutes a real expression. Does it go down to the caterer? Does it go down to selling chairs for the wedding? And is there some way to draw some lines in this? So, Pam, would you start us off?
Sure. So there are two kinds of claims that somebody in the position of Arlene's florists or the videographers might make, one set of which are clearly precluded by existing doctrine. Because the Supreme Court held in the employee division against Smith case several decades ago now, that a law of neutral applicability cannot be challenged on the grounds that it interferes with the exercise of your religion. So if we have a law that says nobody can drink under the age of 18, then a church that says we want to give sacramental wine to 16-year-olds can be barred from doing that. And so one of the questions I think that's brewing up through the system is, should the Supreme Court overrule Smith? Because otherwise, if you have a neutral law, a neutral anti-discrimination law that simply says no businesses can discriminate on the basis of sex or sexual orientation, then you can't come in as a business and say, well, we have a religious reason why we want to discriminate. You have to rely on the way the statute's written. The second one, which is what I think Bob was alluding to, is to claim that being forced to provide a particular service violates your First Amendment rights by compelling you to speak. And at the oral argument in Masterpiece Cake Shop, the court got into discussions about the difference between baking a cake and making an entree. That's the cake entree, that's the dessert entree distinction, which is kind of like the crack powder distinction, not that reputable. What about the person who drives the limousine? Are they covered, but not the person who who performs the who arranges the cakes? There was a fabulous amicus brief in color filed in the case in support of neither side, just making the claim that cake decoration is a particular form of artistry. What made the brief particularly great was it was filed by the firm of Baker Botts. But it had pictures of cakes. There was, there were cakes in the shape of footballs, cakes in the shape of turtles, It's very expressive in the way that, like, a hamburger probably just isn't quite as expressive. But I think the court's ability to wrestle with that and come out with a rule on where precisely the line is going to be hard. Now, the videographer has a lot of Supreme Court cases, for example, that say that movies are a form of First Amendment expression, but there had never been a Supreme Court case holding that cakes are a form of expression. And so I think it will matter somewhat which of these cases the court takes may have a very powerful impact on what exactly it does. Because if you've got, like, the limousine driver having to say, congratulations, Mr. and Mr. Jones, on your wedding, is compelling me to speak, that's not as appealing a case as somebody who says, I make movies for a living and my artistic direction is in there. The thing that I found most interesting about the Minnesota case that you alluded to is it seems in some ways to be a put-up job. This is not a company that's currently making videos of movies. They make commercial films where they're hired to do a product placement film or the like. And then they claim, which I thought was really interesting, that when they go into the movie-making business, they are going to want to retain the ability to put on their website the videos that they make of your wedding. And as far as I know, most people who hire videographers to video their wedding view it as, you're going to make a film and then you're going to give me the film. You're not going to be showing a film to the public of my wedding in which you exercise editorial control to explain, was my wedding a good thing or a bad thing? So it's a kind of, it's a kind of odd case in that way.
Paul, we clearly have a court that is more attuned to religious beliefs and protecting those religious beliefs. It's been shown in several different ways. What do you think the court does here? Do you think that they want this case this term?
Well, I'm not sure they're all that anxious to get it very fast, but I think these cases are going to keep coming, and sooner or later this court will take one. One of the main arguments that the anti-gay forces made after Obergefell in 2015 is that this is an invasion of the space of traditional conservative religious people. And there is essentially one group of lawyers out there finding these cases, encouraging people to adopt these policies, and then litigating on their behalf. And they're going to keep feeding this case up there until they finally get the court to take one, and then they hope 5 votes so that they can get a foot in the door, and then they'll just try to slammed the door wider and wider open with more and more cases about not weddings, but what about, the lawyer who doesn't want to give you legal advice because legal advice involves expression. Why should I have to serve people I don't want to serve, or, the gas station attendant, whatever. There's expression everywhere once you establish these principles. So it's going to be an interesting thing to watch.
Could I just add, one thing that hasn't been said, maybe because it's obvious, is these are the cases where the absence of Justice Kennedy could make such a huge difference. The majority opinion in every Supreme Court case in history so far, expanding rights for gays and lesbians, was written by Anthony Kennedy. And if you think about it, in Obergefell, John Roberts wrote a vehement, vitriolic dissent, and the only dissent he's ever read from the bench since coming to the court was in Obergefell. Justice Thomas and Alito write dissents like that. It's not a blank slate with regard to Justice Gorsuch. In 2017, soon after coming on the court decided a case called Pavon versus Smith that involved an Arkansas law that refused to allow same-sex couples to have both of the parents' names on the birth certificate. And Justice Gorsuch wrote a very angry dissent, joined by Justices Thomas and Alito, that seemed to leave no doubt where Justice Gorsuch would come out. And in Masterpiece Cake Shop, Justice Thomas, joined by Justice Gorsuch, wrote the opinion saying, this is really discrimination on the basis of freedom of expression. And so we don't know where Justice Kavanaugh is going to be, but it is, to me, the key of no longer having Anthony Kennedy there. Just a couple things to what Pam said. In terms of the court maybe being inclined to revisit employment provisions for Smith, early in 2019, the court denied cert in a case called Kennedy versus Bremerton Schools, and Justice Alito there writes an opinion respecting the denial of cert, joined by a couple of justices saying it may be time to reconsider employment division versus Smith. Mm-hmm. And finally, with regard to the speech issue that underlies these cases that Pam was talking about, in some ways this is very frightening, because if the court accepts the speech argument, isn't there an expressive component to almost any work? I mean, think back to the Ollie's Barbecue case. Couldn't then the Ollie's Barbecue say, well, we don't want to have to be forced to speak by preparing and serving food?
It's the sauce icing distinction.
Exactly. In fact, at the oral argument, just in the Masterpiece Case Shop, Justice Breyer said, if we accept the speech argument, it will create an exception to every civil rights law, quote, adopted since day 2. I don't know why he picked day 2 as the phrase. But it really would seem to be, why can't the employers say that it's part of my beliefs that men and women shouldn't work together, or that there shouldn't, it's part of my beliefs that I shouldn't have to provide these services for an interracial couple, and you can go on with all of the examples. And so the stakes of this are so enormous.
Right, well, and you think about other aspects of the First Amendment. Once you would adopt an expression exception, what about the freedom of association? I don't want to have these people who are sinners in my eyes in my pizza restaurant. Why should I have to associate with them? It's forced association.
I probably should have said it in the Masterpiece was summoned to 2. Justices Ginsburg and Sotomayor dissented. They would have left the decision against Jack Phillips in place, but every justice except the Chief Justice wrote separately, so we have a pretty good idea, I think, of where everybody else is coming down on this except the Chief Justice and now Justice Kavanaugh, who wasn't on the court at the time. David wanted to say something.
I was just going to say, I think it became clear at the argument that it's just the wrong, you're looking at the case through the wrong end of the telescope if you're focusing on the business owner and whether what the business owner is doing is expressive or not. Partly for the reason that Pam alluded to, you can't distinguish one business owner from another. The reason that Erwin alluded to, almost anything can be expressive. It's just not a workable way of analyzing the problem. It's also not doctrinally the proper way of analyzing the problem. The proper way of analyzing the problem, according to the prior case law, which rejected the associational argument, rejected the speech argument, rejected the religion argument when it was made to justify race discrimination in the civil rights era, is you ask not whether the individual is engaged in expressive activity, you ask whether the government, in regulating the conduct, is targeting speech, or in the religion context, targeting religion, in which case it's a First Amendment issue, or whether the government is not targeting religion or targeting speech, but acting in a generally applicable, neutral way that happens to regulate both conduct that is expressive and conduct that's not expressive. And if that's the case, the government generally wins. And that's O'Brien versus United States, the draft card burning case. Nobody disputed that when Mr. O'Brien burned a draft card to protest the Vietnam War, of course he was engaged in expressive conduct. But because the government's interest was not in suppressing a particular point of view, but in preserving draft cards for registration purposes, a neutral purpose, it wasn't a problem. And that's the same thing here. And the court, although it didn't decide the question, it did say very clearly, Justice Kennedy's opinion says, the fact that a business owner has religious or philosophical objections to, does not permit him to avoid a generally applicable neutral public accommodations law. So, I think they ended up deciding it in this kind of quirky way, but at the end of the day, I think they'll end up coming out the same way they did on Smith, which is that you can't make every man a law unto himself. And if you recognize a First Amendment exception, you're essentially making every man a law unto himself.
I have a retort here from Justices Gorsuch and Alito, but in the interest of time, I'm just going to do the wince grimace so that you'll know that there's the other side to this, and we'll get to Pam, who wants to tell us, maybe she doesn't want to, but she will, tell us about a couple of other things that are out there, foster care, involving foster care, and again, once again, affirmative action.
Yeah, those are two different things, not
Those are two different
affirmative action and foster care. So the foster care case is a case from Philadelphia where Catholic Social Services was disqualified from continuing to participate in the foster care program because it will not place children with same-sex couples. And so it raises, again, this same kind of issue. But in a different context, and it'll be interesting to see what happens when that gets to the Supreme Court. In the longer term, one of the things that this was a technique pioneered by the NAACP in the 1920s, but it's a technique that both conservative and liberal legal movements have used, is to start cases in the hopes of getting them to the Supreme Court, building a record, and then changing the law. And I think on affirmative action, the Supreme Court has two cases that are in the pipeline that I think are likely to get to the Supreme Court in the next couple of terms. One involving a challenge to the affirmative action program for admissions at the University of North Carolina, and the other, the affirmative action program at Harvard University. And the Harvard case has been tried, and we're awaiting a decision from the District of Massachusetts on that. And I think, this is, I would say, of the social issues, the one that Chief Justice Roberts has devoted more of his career to than any of the others, which is he has been an opponent of affirmative action and disparate impact theory, and from the very beginning of his career as a special assistant in the Justice Department during the Reagan years. And so I think the idea behind these cases is to get an affirmative action case to the Supreme Court, to get rid of affirmative action before the 25 years that Justice O'Connor talked about in 2003 in the Grutter case, where she expressed the hope that within 25 years we will have gotten to the point where affirmative action is no longer needed to ensure diversity in higher education admissions.
Thank you. Does anyone have a question? We have a couple of minutes. Oh, come on, don't make me call on people. Yes.
Well, I wonder if you all think that there's any reason to think that Chief Justice Roberts might look at the current and future gay rights cases differently than past cases because of his kind of new position as the mediator of justice and, sort of his institutionalist leanings.
I think they're just different questions. I think he genuinely believed that it was an inappropriate exercise of constitutional interpretation to read the Constitution to recognize same-sex marriage. That's a very different question than whether a statute that Congress has enacted that prohibits sex discrimination that has been interpreted for years to include sex stereotyping discrimination equally protects transgender people. It's not a constitutional question. It's a straightforward statutory question. And I think these sort of, whether there ought to be a First Amendment exception to laws of general applicability is also a very different question. I think he's shown through some of his questions in some of the arguments, including in Masterpiece Cake Shop, some sympathy towards some kind of exceptionalism for, at least for religious institutions. But in order to get there, he would have to alter constitutional law in a significant way, whereas what he was objecting to in Obergefell was the other side altering constitutional law in a significant way.
Let me just add that one of the interesting things about the court and people observing the court over the last year or so has been all the discussion about affirmative action and Roe v. Wade and other doctrines that are at risk. Nobody ever talks about Obergefell being at risk, and that is, in some sense, a reading of John Roberts is not wanting to go there. So, I mean, at least in that sense, it is an interesting line that at least those of us watching the court have drawn. Hope we're right.
Yeah, and he didn't join the dissent in Pavan. Is it pronounced Pavan? I don't know. The person from Arkansas.
Yeah,
One of the ones we can't tell whether he
Yeah.
good.
So David, you mentioned that like transgender question is sort of new in courts, and I was wondering how does scientific and sociological research, how is that sort of evaluated in some of these cases involving like transgender sexual orientation?
You know, I guess I think I'm not sure it's directly relevant. Neither of us, are arguing that sex, as it was enacted by Congress in 1964, was intended at that time to protect transgender status or sexual orientation in the sense that Congress thought about that. Neither of us is arguing that it ought to be updated, because of, changing understandings of gender in some sense. We're making a kind of doctrinal and logical argument that taking sex to mean what the government calls biological sex, or what you might call sex assigned at birth, when you treat someone differently because of a stereotype that is specific to a particular sex. If you are a male, if you are assigned male at birth, you should live openly as a male for the rest of your life, or if you are a male, you should only be sexually attracted to females. Those are sex-specific stereotypes. They're true of most people, but they're not true of substantial minority of people in the United States. And the enforcement of stereotypes, sex-specific stereotypes, is sex discrimination. So we're not trying to get the court to redefine sex, but just to understand that at the end of the day, an objection to someone for being transgender is an objection to that person not abiding by a particular sex stereotype, and an objection to someone being gay is an objection to that person not abiding by a particular sex-based stereotype.
That being said, I think, if these cases had come up to the court in 1964, the result would not be favorable to our position. I think. I'm prepared to go there. I know I'm going out on a limb here, but, But I do think one way in which sociological or scientific or medical changes has made a difference is, in 1964, homosexuality was still listed as a mental disease in the DSM-1 or the DSM-0.5 or whatever DSM they were on at that time. And it would be much harder to make the argument at that time because the court would think, well, you're refusing to hire people who are mentally ill, who are committing crimes, because it was a crime in most of the states in 1964 to engage in most forms of homosexual activity. And so those changes, will have an underlying influence on the court, because it will be more ready to follow where the text leads when the text doesn't lead them to say people who are mentally ill deserve protection on grounds of sex discrimination.
Right,
So-
well, and certainly the amicus briefs that the court has received in all these gay rights cases over the years have intended to teach the justices the reality of what we currently believe and understand about gay people and lesbians, gay men and lesbians. And you know, as David commented, they have had less opportunity to receive those amicus briefs from the groups talking about the reality of transgender people, but they will continue to get educated about that. I'm sure in Stephen's case, there's groups that have come in and said all sorts of background information for the court's reference. It's one of the things the court needs, is to have a way to learn about the real world that in cases where those kinds of scientific facts are relevant.
Yeah, well,
I'm sorry, that's going to have to be our final word, right?
Oh, no, I get to the final word, even though this isn't the final panel, because usually we're the final panel, but this year we're not. And so I get to say thank you.
Pam gets the final word.
So I get to say, first of all, thank you, Neil, for everything you've done with this conference. And also, thank you to Sammy.
So the conference is not actually over. There is another panel that will begin in 10 minutes, but let's thank these panelists first.
Thank you. I'm going to run to the airport now.
Now it'll be said by...